Hi, everyone. It's Laura, the real Laura B, here on YouTube and on Twitter. And I am back with, well, it's a rather long video, but it is a deep dive on Melanie Iglesias. And this covers several continents. And this is part of my pre-trial battlefield for the Depp v. Heard. But this one starts in Virginia, jumps over to the UK, goes back to California, and then ends in Virginia. And this woman fought a hard battle to stay out of this. So let's see what happened and the inconsistency testimony and what the Virginia jury got right. Hang in there.
Hi, I'm Laura, also known as TheRealLauraB from Twitter, and now here on YouTube. I'm a researcher, new wave internet media, and commentator. I'm not a lawyer nor offering any legal advice. Join me on a journey to review the world of celebrity lawsuits and current events. Let's get started.
Hey again. Well, this is a deep dive, and this has lots of documents that I purchased from California and various other places to bring to you what actually happened with Melanie Iglesias. And I think it's better to dig right into it. Melanie Iglesias is a friend of Amber Heard. She was her makeup artist. She did her makeup for the James Corden show on December 16th, and there's conflicting testimony if she was at the Penthouse on December 15th. After Johnny had left and after Amber Heard apparently had that major allegations of a big fight, which included the banging of heads. Anyway, she had given a declaration apparently in Virginia and sometime in June, July 2019, and NGN decided, you know what, we want her to testify and we're going to do everything we can to make that happen. So let's get started. So here on March 5th of 2020, NGN makes an application in the California Central District of California to compel Melanie Iglesias to give testimony, live link from California. And they're saying it's a jurisdiction because they have jurisdiction. This is an international filing they're making. The Sun is incorporated under the laws of England and Wales, and it's a registered office at 1 London Bridge Street. Respondent Melanie Inglesis is a resident of Los Angeles, and she had given a deposition, or she had been served a deposition subpoena by Johnny Depp. So that made at the certain Los Angeles address, and they attach that. They also attach her profile of her LinkedIn, identifying her as a resident of LA and working as a makeup artist. And a printout page from the Forward Artist website showing Miss Inglesis on its roster of makeup artists. The application is made pursuant to the USC code. The court has jurisdiction for where she lives. The venue is proper. And we know the background facts are that NGN are the defendants in an action being brought against them by Johnny Depp because of the article that Dan Wooten wrote. The English action is a libel claim by Johnny saying that the title was wrong and that he was guilty of overwhelming evidence of serious DV against his ex-wife. We know how all this went. What's important is what is the importance of her testimony? Jeffrey Smeal is a London solicitor representing NGN. In his declaration in support of this application, he explains why Miss Iglesias is a crucial witness for the petitioners. His declaration is based on the pleadings and evidence in the English action on which he has learned from other witnesses, including Miss Heard's 2016 deposition in another matter, and from Miss Heard via her London-based barrister, who also acted as an intermediary between his firm and Miss Inglesis. His declaration states as follows. Miss Inglesis is a makeup artist and friend of Miss Heard. She witnessed the immediate aftermath of Mr. Depp's violence towards Miss Heard on December 15th. Let's note that date, including Miss Heard's injuries. The following day, which would be December 16th, Miss Iglesias applied makeup to cover Miss Heard's injuries in advance of Miss Heard's appearance on the Late Late Show, hosted by James Corden. Miss Iglesias discussed this incident with other witnesses, including Miss Heard. Mr. Depp claims that Miss Heard fabricated the alleged violence on December 15th and claims that the day after the alleged incident, Miss Heard had no visible injuries on her face. Mr. Depp has submitted a declaration from Samantha McMillen, who will play an important role in this, which supports his account. She's a freelance stylist who was present on December 16th and says she observed Miss Heard to be uninjured. Miss McMillen will also be a witness for Mr. Depp in the English action. Ms. Iglesias' evidence is therefore especially important as it directly contradicts the evidence given by Ms. McMillen. Ms. Inglesis was at a birthday dinner on April 21st, and that's a different story. We're not going to be worrying about that, or on the May 21. For my presentation here, we're going to concentrate only on the James Corden December 15th, 16th timeframe. So we'll go ahead on that. In order to obtain Ms. Inglis' crucial testimony at trial, petitioners respectfully request this court to issue an order compelling her testimony. Specifically, petitioners request that this court issue an order as set forth in the proposed order filed concurrently herein, that Ms. Iglesias shall attend the Beverly Hills Bar Association to give her live-link testimony at some point before the trial. The application is made pursuant to the pre-trial review of the English action on February 26, 2020, when Mr. Justice Nichols, a high court judge, gave permission for Ms. Iglesias, along with other witnesses, which included Laura Divinier and the LAPD police officers, to give live evidence at trial. So the Judge Nichols is saying they don't have to come to England to testify. We're giving permission for them to do via live link testimony in their respective towns, Beverly Hills. Taking Ms. Inglesis' deposition is not an option because deposition testimony is not generally admissible under English law. Now, we saw deposition testimony being used and edited and presented video in the Virginia trial, but we also saw live link. Petitioners, that's NGN, have tentatively selected April 1st as their best date for Ms. Inglesis' testimony and request that she be ordered to appear at the designated location and time. Now, we know the trial got delayed because of the pandemic. Good cause exists, and our conclusion is please grant us that. So let's jump to the order. I'm not going to read every one of these pages. So anyway, what's happened was at some point, Melanie Iglesias gave a sworn declaration in Virginia. And this is the basis of what NGN is saying, why she's such an important witness. As you know, many people in the case gave witness statements in the UK. Melanie refused. So what they did is the Heard team, someone turned over her declaration that she gave sometime in June, July 2019. And from that legal declaration, they created a witness summary. If we call Ms. Iglesias to testify, this is what we expect her to testify to. And again, we're only interested in the December 15th incident. The first time I saw the physical evidence of Johnny's DV was before Amber was scheduled to appear on The Late Show with James Corden. Amber and I were supposed to go bowling the night before, but Amber told me that she could not join because she had been in a bad fight with Johnny. I came over to the Eastern Building to apply makeup before her TV appearance. And so this is the next day. As I walked into her kitchen, I saw writing on the countertop in gold marker. There's a photo attached. It's a true and correct copy. I also saw that a number of Amber's possessions had been smashed or destroyed. There was, when she says a number, I remember the photo, there looked like there was a few knickknacks that had been dropped on the floor, but that's here nor there for this discussion. When I saw Amber, I immediately noticed that she had a split lip and a bruise near her eye. I also saw that there was a chunk of hair missing from her head. Amber told me that Johnny had tried to suffocate her. Throughout the time I was applying makeup on Amber's injuries, we discussed whether it would be possible to keep the fact of Johnny's violence a secret. Amber repeatedly told me that she did not want to expose this part of her life to the public and that she was considering canceling the appearance altogether. That she was considering canceling the appearance altogether. Well, Melanie was already doing the makeup and she had her hair done, and we know that Samantha McMillen was there, her stylist, so I think that was a bit late. I also remember Adair Abergel, Amber's hairstylist, was working on Amber's hair while I did Amber's makeup. Adair and I both discussed how we noticed that Amber had a chunk of hair missing, and Adair noted that he was being careful working around the missing chunk to cover it up. Now, Adair Abergel was on Amber Heard's witness list. We never saw a subpoena issued for him, so I was shocked when I saw him on the witness list, but he never testified in Virginia. Meanwhile, I was working on Amber's makeup and distinctly remember having no choice but to use bright red lipstick that day because it was the only way to cover the injury on her lip. I was also able to cover the bruise adjacent to Amber's eye, a single bruise. After I finished applying her makeup and Adair finished and Amber's hair, we all went to the studio for Amber's appearance on the James Corden show. While there, Amber turned it on and hid the emotions that she shared with us at the penthouse. As I've seen her act on numerous occasions, numerous other occasions to prevent others from learning about troubles with Johnny. However, looking back at the pictures from that appearance, I can see where Amber was bruised and her lips had been injured. Well, apparently she's the only one. Jumping ahead. So the judge did agree and did issue an order. The court has considered petitioner's application. Remember, she gave a declaration, so they figure she's already involved. We're going to let her testify in LA or Beverly Hills. So the court in California said, yep, we're going to grant the application for compelling respondent Melanie Iglesias to provide testimony in the foreign proceeding entitled Depp v. NGN and Dan Wooten that is currently pending in the media and communications list of the Queen's Bench Division in the High Court of Wales. So accordingly, it is hereby ordered on April 1, respondent Melanie Iglesias shall appear at the Beverly Hills Bar Association to testify via live satellite video link. Now we know that date got changed because of the pandemic. The trial got delayed. If respondent's testimony cannot be completed on the first day, it shall resume the next day as set by the High Court. Respondent's testimony shall be subject to English legal practice and procedure. Respondent's testimony shall not exceed a total of 7 hours. Petitioners may change the date, time, or location, but only if they notify her and her counsel, Anya Goldstein, who my understanding is was paid for by Amber Heard, and that's been in declarations or motions filed by Amber Lane Braderhoft on behalf of Amber, saying that yes, they did provide counsel to her witnesses because they thought Johnny's team were bullies. And they wanted to help protect him. Petitioner shall reimburse respondent for the time she spends testifying at her usual professional rate. So they were going to pay her for giving her testimony, which isn't unusual. So this goes to show you that in the UK, they were able to compel U.S. residents to give testimony, live link testimony from their home area. And I'm surprised that Depp team didn't pursue more witnesses, but this is where we're at now. Well, as you can imagine, this didn't sit well because the last thing Melanie Iglesias wants is to testify. So this is Melanie's attorney going, yo, you didn't follow the rules. You didn't serve her properly. You gave me the information, and this urgency that you suddenly rushed it isn't going to hold up. So they filed the urgency on the Monday before the trial, or the trial's going on Monday, and they have known at least since December 4th, this is dated March 2020, they've known at least since December 4th that Miss Inglesias would not voluntarily testify through the UK proceeding. Now, on the eve of trial, in the midst of both an emergency of its own making and a real global pandemic, NGN wants this court to reward its poor planning and trample the rights of Miss Inglesias, an uninvolved third-party witness to a foreign proceeding. NGN has rung Miss Inglesias' buzzer 3 times. That was at her actual home. It has not performed a stakeout, and it has made no attempt to determine when she is likely to be home. But even if these attempts constituted reasonable diligence, the substitute service permitted would be service on an adult at her home, coupled with mailing, or, if that failed, a motion for a court order by service by publication. There is simply no provision under California law that allows a court to order service of process via a lawyer who is explicitly not authorized to accept service, as is the case here. And we saw that in the Virginia trial when Heard's team tried to subpoena Adam Waldman and sent it to Ben Chu and not directly to Adam Waldman. And Ben Chu said, no, I'm not authorized to accept service of a subpoena on behalf of Adam Waldman. And the Virginia courts agreed. Moreover, ex parte relief is inappropriate here because NGN failed to give ex parte notice. And more importantly, NGN is at fault in creating its own need for urgent relief. They had plenty of time. NGN has provided no reason why it waited until the eve of trial to file this action and serve the resulting order on Miss Inglesias. That it has now run out of time to do so is not valid grounds to waste the court's valuable time and force Miss Inglesias to immediately respond to a baseless request. As this court is well aware, we're in the midst of a global pandemic of ever-growing proportions. In light of Governor Newsom's order directing California residents to stay at home, Mayor Garcetti's similar order for residents of Los Angeles and the Central District order closing to the courts of the public until May 1st, 2020. The guidance of the World Health Organization and the CDC and numerous state and local health agencies directing individuals not to travel or meet in groups. The recent statement of Professional Responsibility Ethics Committee that lawyers should act cooperatively to avoid in-person meetings, hearings, or deposition obligations, and so on. Ms. Iglesias, through counsel, attempted to meet and confer with NGN on March 19th regarding both the pending ex parte application and the underlying order, which, when served, will require Ms. Inglesis to appear at a semi-public place where she will no doubt be required to interact with other unknown individuals on April 1st, shortly after plane travel across the country. Well, there's a key there. She's not in LA. We'll find out later that she had gone to stay with family in Florida. As of the time of this filing, NGN has not responded substantially. In order to protect Ms. Inglesis' rights and provide the court with her position on the pending ex parte application regarding service before the telephonic hearing, Ms. Inglesis, especially appearing through counsel to preserve her objections to service and personal jurisdiction, submits this opposition on the threshold issue of service. But should Ms. Inglesis be served, whether as a result of the pending ex parte application or otherwise, Ms. Inglesis anticipates filing a motion to quash the order compelling testimony on April 1st, which is just on the other side of the weekend. And this is really interesting because if the trial had not been postponed, I'm not sure Melanie would have ever testified at this point. NGN's request of relief is not authorized by law. NGN and Ms. Inglessis' view of the applicable California law diverges widely. True, some courts have determined that a few attempts at personal service are sufficient to allow for substitute service, but the substitute service then permitted is service under this code, leaving the documents with an adult apparently in charge of the person's home or office and then mailing the documents to the home or office. If substitute service, which NGN has apparently not yet attempted, is not effective after reasonable diligence, a party may move the court an order permitting service by publication. So this is interesting, and we probably don't have to read the whole thing because we know the trial got delayed. So they were fighting back and forth like, hey, you didn't serve me. My lawyer is not allowed to accept service from me. You didn't attempt the multiple times of servicing or trying to get to an adult or going through the mail or applying for publication. Ex parte relief is inappropriate where the crisis is of the applicant's own making. NGN first notified Ms. Iglesias through counsel of its ex parte application and indeed of the existence of this case at 1:56 p.m. on March 19th, 2020, after counsel for NGN and counsel for Ms. Iglesias had received a call from the court's courtroom deputy seeking to schedule a telephonic hearing for March 20th. So at 2 o'clock in the afternoon on the 19th, they were trying to schedule a hearing on the 20th. In violation of this court's rules, NGN did not notify Ms. Iglesias' counsel before making ex parte application, seeking her position on the application, or advise the court of her position. Even where proper notice is given, ex parte applications are inherently unfair because the applicant is able to time its application strategically, whereas the responding party must drop everything and attempt to respond in days or hours. We saw this happen to Johnny Depp from when she was filing for the TRO. Laura Wasser testified that they filed ex parte with no notice to them, and they were unable to respond fast enough to prevent the TRO from happening. Therefore, ex parte relief is only appropriate where, one, there is evidence to show the moving party will be irreparably prejudiced if the underlying motion is heard according to regular notice motion procedures, and where the moving party established it is without fault in creating the crisis that requires ex parte relief. Part 1 of this test is arguable and will be addressed more fully in her motion to quash, but NGN surely fails Part 2 of this test. As noted, NGN has been aware for 3.5 months at least since December 4th that Ms. Iglesias would not testify voluntarily in the foreign proceedings. NGN then apparently sat on its hands until March 5th, just 2.5 weeks before their foreign trial was due to start, to initiate this proceeding. In other words, NGN initiated the proceeding after the point where it could have filed a regularly noticed motion to be heard before its foreign trial began. And Ms. Inglesis is aware of none, nothing's been filed for no later than 28 days. The NGN was then not able to serve Ms. Inglesis in the 3 days it allotted to itself to do so is NGN's fault and no one's else. So they're asking for this to be denied. They do file their motion to quash. Please take notice that on June 15, 2020 at 1:30 p.m. or as soon thereafter as the matter may be heard. So we've jumped now. This is dated May 16th. As soon as this order can be heard in the courtroom, order such that it does not require Ms. Inglesis to leave her house before state and local stay-at-home orders are lifted. Ms. Inglesis makes this motion on the grounds that the court should decline to exercise its discretionary power to compel Ms. Inglesis, an unwilling, uninvolved third party, to testify in a foreign proceeding under 1782 because, one, NGN could procure her testimony without it. Committee and party weigh against the grant of discretionary relief. NGN's request poses a serious risk to and places an undue burden on Ms. Inglesis in light of the pandemic, the death threats and harassment she has already faced, and the risk to her career. More on that. The burden placed on Ms. Inglesis is undue because NGN rejected her reasonable alternative proposal. And NGN's misuse of the 1782 process should not be rewarded with discretionary relief at the expense of the uninvolved third party. And I'm not doing the deep dive into all the codes. Is this really what I'm presenting is a story of a timeline of how this meandered along? So I'm not getting into much of the legal stuff. At the time of the filing, Chief Judge orders activating the continuity of operations plan. So what she's saying is, look, there was already this pandemic ruling in places. The COOP currently provides that hearings in civil cases will only go forward by video or telephonic conference. Should the COOP be extended, Ms. Inglessis respectfully requests a video or telephonic hearing. Or she's not talking about her testimony. She wants a hearing on this. Ultimately, submission of the matter without hearing such that the parties may receive a ruling before NGN seeks to compel her. Motion is based on the notice and supporting memorandum and points of authorities, etc. We're going to go to the background. We've already covered the background. NGN did not notify Ms. Inglesis of the filing of the ex parte, so she was not provided the opportunity to be heard before the court issued its ruling that she should be compelled. The ex parte order required Ms. Inglesis, once served, to appear to testify in the UK trial via video link from Beverly Hills. By the time NGN filed this first ex parte application, both California and Los Angeles had declared a state of emergency due to the pandemic. So NGN was unable to serve Ms. Inglesis with the 1782 order. In the 3 days, it had apparently allotted itself to do so before trial, and that's repetitive. We know at that point that they just delayed it to the last minute, even though they had known for many months. And as late as March 20th, 2021, after Governor Newsom had ordered a legally enforceable statewide shelter-in-place order, NGN persisted in its attempt to compel Ms. Inglesis to fly from the Florida Keys, where she was located at the time. She was staying with her family. She has a son. Back to California in order to testify in Beverly Hills, where she would no doubt have been required to interact with other unknown individuals. Despite being in contact with Ms. Inglesis on other matters, NGN did not provide notice to Ms. Inglesis seeking her position or provide her position to the court in the second ex parte application. So there's a lot of pushing going on with her that they need her to testify, and she's doing everything she can to avoid this. Now, prior to, they said, the trial was supposed to start. She wasn't available. Of course, the trial got delayed. And where's Melanie? She's in the Florida Keys. I'm not saying she flew there to avoid testifying. There is a pandemic. There was a reason for her to be there with her family. But it's just all interesting in the timeline. So they filed the second ex parte application on March 19th, and both NGN and Ms. Inglesis had received a call from the courtroom deputy seeking to schedule a call within 12 hours. So we covered that already. Approximately 6 hours after Ms. Inglesis filed her opposition, NGN sought to postpone the telephonic hearing. NGN eventually withdrew their second ex parte application because the UK trial was continued, not because it recognized the unreasonable risk posed to Ms. Inglesis. The UK trial has now been rescheduled for July 7th. Well, this doesn't pose well for Melanie because now they've got plenty of time to pursue her. NGN has notified Ms. Inglesis it will seek to compel her testimony at some date between July 17th and July 28th, irrespective of the status of the pandemic at that time. In an attempt to avoid the need to file this motion, Ms. Inglesis offered to be deposed in the related U.S. case, Depp v. Heard, currently pending in the Circuit Court of Fairfax, Virginia, prior to the UK trial, so long as she could do so safely, such by video link from her own home. And we saw a lot of people that did those kind of depositions from their home, such that NGN could use her deposition testimony in the UK trial. NGN did not dispute the key issue in the UK action, whether Mr. Depp did whatever. I'm not going to read it all. NGN did not dispute that it seeks the exact same testimony that counsel in the U.S. matter would seek, whether Ms. Inglesis saw injuries on Amber's face in December 2015. NGN did not dispute that the deposition testimony would be admissible in the UK trial. In fact, for other U.S. witnesses, NGN had foregone the 1782 process in favor of using U.S. deposition testimony. But NGN rejected Ms. Inglesis' offer, stating the deposition testimony would carry less evidential weight in the English proceeding than live testimony, and therefore it preferred to pursue it. After multiple meet and confers failed to resolve Ms. Inglesis' concerns, she was forced to bring the instant motion to quash. So we're going through with this. Again, it's going to go through the legal actions. And again, I'm just here for the story part of it. And it goes on to say, NGN could procure Ms. Inglesis' testimony without the 1782, even though she's not a participant in the foreign proceeding. As explained above, basically they're saying you could have taken my deposition, used the U.S. deposition, because NGN could procure her testimony without resorting, but has chosen not to because of a perceived tactical advantage in its foreign case. This factor weighs heavily against NGN. Now, a deposition would have been an edited video that they played in court if the UK court allowed it. They want her to do a live link testimony. They talk about, again, the pandemic, that her safety precludes this, puts her safety and her career at work, and her career at risk. Even if it were not for the pandemic, NGN's request is unduly burdensome because it puts Ms. Inglessis' safety and career at risk. As NGN recognized in its initial application, Ms. Inglesis has no interest in being a witness in this case. She is an uninvolved third party. She's made no public statements about this case. Nevertheless, based on her perceived association with this matter and anticipated testimony, which apparently is presumed to be favorable to Ms. Heard and therefore to NGN, Ms. Inglesis has received death threats and faced online harassment. This case and the related U.S. case are high-profile matters providing international celebrities and are receiving intense media scrutiny. Ms. Inglesis generally fears for her safety as it is, and if she is forced to testify for NGN and by extension for this controversial tabloid, The Sun, the threats and harassment she faces will undoubtedly escalate. NGN's request also jeopardizes Ms. Inglesis' career. Ms. Inglesis is an acclaimed celebrity and high fashion makeup artist. Her clients place a premium on their privacy, frequently requiring her to sign non-disclosure agreements before working with her. If NGN's request is granted and Ms. Inglesis is forced to testify publicly in this high-profile matter about things she saw in a celebrity client's home while she was working, Ms. Inglesis' career will undoubtedly suffer. Despite aware of her concerns, NGN has made no efforts to seek confidential treatment of any testimony procured from Ms. Inglesis or otherwise mitigate the burden it requests put on her. The burden placed on Ms. Inglesis is undue because NGN rejected her reasonable alternative proposal. As explained above, Ms. Inglesis proposed a reasonable alternative that would not have imposed an undue burden on her. She agreed to be deposed in the U.S. matter such that NGN could use her deposition testimony. This proposal would have resolved both parties concerned. NGN would have her testimony to use in the case. Again, the issues in the case are identical, and she would only have to testify once in a forum that she expects to be subject to the party's subpoena power, rather than a forum where her participation is up to the court's discretion and could do so safely. So this is how it goes. Continues on, that they want it to stop. violating the rules and putting her at risk. Moving onwards. Then they submit her actual declaration. Now remember, this is the U.S. declaration that they use to create a witness summary. And it pretty much starts and says the same thing. I came over to the Eastern Columbia building to apply makeup before her TV appearance. When I saw Amber, I immediately noticed a split lip. So they've pretty much taken the same exact thing that she said in her declaration. And then we have NGN's solicitors now giving declaration. On or about December 4th, I was told by Anya Goldstein, who represents Melanie Iglesias, that her client would not give evidence in the English trial voluntarily. However, I had subsequent conversations with Ms. Goldstein, which suggested that Ms. Inglessis might change her mind. For example, on January 27th, Ms. Goldstein stated in an email to me that she believes Melanie is still a no, but will be speaking to her again. Now, she's supposed to be representing Melanie, and Melanie is not interested in this. So I'm not sure why her lawyer is working with NGN to try and talk her into giving testimony. That's what I'm reading here. Together with my colleague, Jeffrey Smeal, I flew to Los Angeles in February, in part because we hoped to meet with Ms. Inglesias in person and persuade her to change her mind, but she declined to meet with us. On February 4th, we met Ms. Goldstein at her office in downtown Los Angeles, but to no avail. In a final attempt to try to obtain Ms. Inglesias' agreement to testify voluntarily, I emailed Ms. Goldstein on February 17 stating, I referred to our recent meeting at your office and specifically on the ongoing discussion about your client, Melanie, following her refusal to cooperate with our request that she gives evidence along the lines of her witness summary in the London proceedings brought by Mr. Depp against my clients. I mentioned that I might be instructed to commence proceedings with her to be subpoenaed by the Los Angeles District Court. This will be to give video link evidence under the Hague Convention and appropriate English and U.S. rules for her to attend a Los Angeles location during the trial to give evidence over live video link. I have now been instructed to do so by my clients. Please can you ask your client on one last occasion to reconsider her decision before this process is commenced. Melanie did not reconsider, which left our clients with no choice but to file the ex parte application. English courts are generally much less receptive to deposition testimony than U.S. courts, and they treat them as hearsay evidence. Moreover, if a party could have produced a witness to testify live at a trial, but does not do so, and instead proffers a deposition transcript, an English judge is likely to give far less weight to the testimony. So they weren't even offering the video deposition. I guess they're now saying that they would only offer the deposition transcript. Because all civil trials in England are most exclusively now non-jury, there is much more focus on the weight that a judge will give a piece of evidence than on whether the evidence is admissible, inadmissible, or inadmissible. English judges are generally less likely to rule the questionable evidence is inadmissible because there is no danger that such evidence could be wrongfully influence the jury. We also have declaration from Alexander Rufus Isaacs. So he is NGN's U.S. attorneys. After being retained, petitioner's California counsel, Mr. Isaacs contacted Ms. Goldstein, informed her that an application under Rule 1782 would be filed shortly and asked if she would accept service on her client's behalf. After the court issues its order on March 11th, I instructed our attorney service Express Network to send process servers to serve the order and the application on Ms. Inglesis at her home address in LA. I learned from Ms. Goldstein's declaration on March 20th that Ms. Inglessis was in the Florida Keys during that period when our process servers were retrying to serve her home address. On Monday the 23rd, petitioners formally withdrew their ex parte application, and shortly after, they recommenced their attempts to serve Melanie. Our process server finally effected substitute service on Melanie on April 16th. Attached hereto is an exhibit and a correct copy of the declaration that was provided me by the Express Network. So somehow they did substitute service, whether they left it in the house, they mailed it, they posted it on the door, or they found somebody to hand it to. On April 30th, a new trial date in the English action, July 7th, was set by the High Court. We emailed Ms. Goldstein the same day about the new date and informed her that Ms. Inglesis would probably be required to testify between the 17th and the 28th. So The English High Court has strict requirements for video conferencing technology, so you can't just do it at home. You have to do it in a set place because you want to make sure no one's sitting there influencing you. So they have these very specific rules. They want to make sure that no one's like holding cards up saying you answer, don't answer, or they want to in this case, the Beverly Hills Bar Association office, where they are equipped with sophisticated video conference equipment and meets the High Court technical requirements and otherwise a convenient location for her. Trial bundle made up of the number of ring binders containing exhibits and stuff would be delivered there for her to look at. All reasonable efforts will be made to ensure her safety when she visits the Beverly Hills Bar Association office to testify. They've arranged for a professional cleaning service. So all of this, as you understand, if another witness will be testifying before her, will be asked her to stay in her car or adjacent area. So they're going forward this. Well, here's what's interesting. Declaration of Jennifer Robinson in support of the opposition to quash. Now, Jennifer Robinson was supposed to be Amber Heard's personal UK attorney. And this is what she says. I'm a barrister, duly admitted to practice in England. I advise Amber Heard in relation, here, let me make this, I'm so sorry. I'm a barrister. I advise Ms. Amber Heard in relation to various matters, including the proceedings brought by Mr. Depp against NGN and Dan Wooten. I have firsthand personal knowledge. In my role as counsel to Ms. Heard, I've been in contact with various potential witnesses who can give evidence about the issues in the English action. Among those witnesses was Melanie Iglesias. I have read the motion to quash filed by Ms. Inglesis in these proceedings, and in particular the following passage on page 12. In its application, NGN stated that it learned Ms. Inglesis anticipated testimony from Ms. Heard's London-based barrister. It also implied to the court that the barrister spoke to Ms. Inglesis. The barrister acted as an intermediary between NGN and Ms. Inglesis. That is not the case. As far as she is aware, Ms. Inglesis never spoke to Ms. Heard's barrister. And some of what NGN implies Ms. Inglesis witnessed is incorrect or misleading. Contrary to those assertions, I have in fact spoken to Melanie on 2 occasions. The first was a telephone call on July 18, 2019, when I was in Los Angeles with Ms. Heard. Melanie had already spoken with my U.S. co-counsel at that time, Rick Schwartz, at Brown, George Ross in Los Angeles, and had provided a written declaration in connection with the defamation proceedings brought by Depp against Heard. So now we know where the declaration came in, which I had read. A true and correct copy of the declaration we've already gone over. I called Melanie to explain the English action and asked her if she'd be willing to provide a witness statement about some of the same facts. I explained to her that I was Ms. Heard's counsel in the UK and that I was independent from the legal team for NGN, and I was calling her to ask if she would consider giving witness evidence in the English accent. I explained that while Depp was suing NGM, Mr. Depp was claiming that Ms. Heard had lied about the abuse she had suffered. During the conversation, Melanie told me that she was willing to give evidence in the proceeding against Ms. Heard in Virginia, but that she did not want to give evidence in support of the Sun newspaper. We discussed her reasons for drawing that discussion. The second time I spoke with Melanie was August 13, 2019. I called her with 2 of my U.S. counsel who represent Ms. Heard in the defamation proceedings in Virginia. So she's saying, hey, she's saying I never talked to her, but I did talk to her. Now we have the second declaration of Anya Goldstein, that she's an attorney, that she's filed to quash this. On June 5th, I visited Los Angeles County's public health website, and what this declaration basically encompasses is all the updates and ongoing problems of the pandemic, why everyone's shutting down, and why it would be unsafe for her. Ms. Inglesias' deposition proposal addressed the pandemic by providing that she would give testimony via video link from her own home if necessary, which is a service that many court reporting companies such as Veritex Legal Solutions and Planet Depots are providing. I never told counsel for NGN that Ms. Inglesias was likely to reconsider or that NGN should delay its request until it heard back that the answer was still no. I represent other witnesses in the matter. We know that. And the February 4th meeting referenced in NGN's opposition was between counsel for NGN and another witness. I think probably maybe Laura Devinier at the time. Another witness. NGN's counsel repeated, as they often did, that NGN would like Melanie to voluntarily testify. But again, I did not tell NGN's counsel that Melanie would reconsider, or that it should hold off on initiating its proceedings against her. I conferred with counsel and NGN on April 10th, April 29th, May 4th, May 12th, May 14th, in an attempt to obviate the need for the motion to quash. As part of the April 10th meeting and confer, I told NGN's counsel that one of the grounds for Ms. Inglesis' motion would be NGN's inexcusable delay in filing its application. NGN's counsel did not on that day or during any of our subsequent meet and confers provide any justification for its delay in filing the application. On April 10th, meet and confer. I also raised a ground for motion NGN's misrepresentations to the court of what Ms. Inglesis witnessed and how it came to know of what she witnessed, including specifically that, as far as Melanie was aware, she had never spoken to Ms. Heard's London-based barrister. We now know that from the prior filing, these are all in the same, I've got these in date orders, but she's saying that Jen Robinson is saying she absolutely spoke with her. I would have informed NGN that Melanie was in Florida if NGN's counsel had provided notice to me before NGN filed its second ex parte application. Attached is a true and correct copy of Judge Wright's March 25th order regarding Laura Duvenier. So this is the ongoing battle that Melanie just does not want anything to do with this. Now this is filed by NGN and they are now formally opposing the motion to quash. And they have all these objections that this is has received death threats. That's hearsay. She's generally in fear for her safety, lacks personal knowledge for that. They're trying to say why they should overrule her filing for the quash. If she is forced to testify for NGN, by extension for its controversial tabloid, The Sun, the threats and harassment she faces will likely escalate, lacks personal knowledge, lacks foundation, speculative. Her clients place a premium on their privacy. That's all hearsay, it lacks personal knowledge. Declarant has shown no basis for her personal knowledge of these facts. If Melanie is forced to testify publicly in the high-profile matter about things she saw in the celebrity's home while she's working there, her career will likely suffer. Again, lacks foundation. Declarant has shown no basis for this. I'm informed and believe that as far as Ms. Inglesis is aware, she never spoke to Ms. Heard's London-based barrister. Lacks knowledge, lacks foundation. So these are all the objections. Some of what NGN implies Ms. Inglesias' witness is incorrect or misleading. That's going to be interesting. Lacks personal knowledge, etc. Ultimately, Melanie lost. The motion to quash the compelling order of testimony has been denied. For reasons set forth on the record, we don't have those. The respondent, Melanie Iglesias, is ordered to appear for testimony via live satellite video link at the Beverly Hills Bar Association. So she did lose. And we knew that. We knew she finally did give testimony. This is, sorry about that, guys. This is the declaration of Amber Heard that she filed in Virginia, April 11th, 2019. And she talks about what happened to her on December 15th. I had plans to meet with my friends Raquel Pennington and Melanie at Johnny's and my penthouse in Los Angeles. Before they arrived, Johnny picked another fight with me, and he sure goes on to make her allegations. At some point, the fighting continued into the bedroom. What's important here is the first thing I remember after the fight was Rocky coming into my room and screaming, "Oh my God, oh my God, oh my God," as she saw me, together with Melanie, who had also arrived. We called Erin Borum, a nurse, who instructed us how to conduct a concussion check over the phone. I had severe headaches and other pain for at least a week. Amber Heard has gone on legal record under oath that at the time, December 15th, after Johnny left, she didn't remember anything until she heard Rocky yelling and she saw Melanie was there. I later learned that when Rocky and Melanie arrived, broken glass and chunks of hair were strewn across the downstairs of the penthouse. True and correct copies of my injuries when we saw the one picture of the hair. Johnny had also written a message. We saw photos of that. That night I texted my publicist. I asked Melanie and Rocky to help cover up bruises, bleeding, and swelling so I could make it to the late show appearance without exposing Johnny. This is how stories change. A day or two later, I went to Dr. Kipper's office for the concussion check. So this is what Amber Heard has gone on record, that Rocky and Melanie arrived the night December 15th. She had no recollection until she heard them yelling. That's what woke her up. I guess she was unconscious. Melanie was there. This is now statement by Amber Heard in the UK witness statement. My friends Raquel Pennington and Melanie had been due to come over earlier that night. Now it's suddenly, I can't remember if Melanie came into the apartment because I was in a daze, but I remember Rocky coming in and we called the nurse to do a concussion check over the telephone. I had horrible headaches. We took photos of the splintered bed and the injuries, etc. I was supposed to appear as a guest on the Late Late Show hosted by James Corden the next day. My face was all bruised. And I was very shaken up and upset. So I texted my publicist just before midnight that night saying I might not be able to make it, that I was bruised and might have 2 black eyes and I would have to see how things are in the morning. That night and the next day were really hard. I ended up deciding to do the show. I remember being in pain and had some difficulty getting ready. I remember they put a lot of makeup on me to cover the bruises. She keeps saying they, and I wore red lipstick to properly cover up my bleeding lip. I remember it hurt when they did my hair. I was especially upset all day, but I just got on and did my job. So this is her statement now that now it's a little wishy-washy. Was Melanie there or not? This is her UK statement. And this is Rocky's UK statement. On this occasion, Amber asked me to come over to her place to check her out. Amber asked me. Amber's statement was she was apparently unconscious until she heard Rocky going, oh God, oh my God, oh my God, with Melanie. I could see that her head was bloody where a chunk of hair had been ripped out from the back of her head close to the crown. Her face was red and her nose was swelling. Her lip was bleeding. She told me that Johnny had in the head. She said he might have broken her nose. I helped Amber with her injuries. Oh, I'm sorry, guys. I helped Amber with her injuries. We called the private nurse who was a part of the concierge medical service, which Johnny and Amber used. I then took photographs with my phone of her injuries. And this is what comes into the issue with the metadata in the UK in the Virginia, because when they collected Amber's photos, they were not initiated on her devices. I then took photos with my phone of her injuries. I photographed Amber's face and took photos of the apartment. There was broken glass under the dining room table. In the kitchen, a message was scrawled. I then went upstairs and took photos of the damage. I photographed a big clump of hair. I don't know why she didn't get all the hair that was strewn all over the apartment, which was blonde in color and clearly belonged to Amber. There was also a wooden platform bed. So let's see, is there anything else about Melanie? The next day, Amber had an appearance on the James Corden show. I was at Amber's apartment as she got ready for the show. Amber and I were exhausted, and Amber was shaken, upset, and trying to pull herself together for the show. Samantha was styling her. Melanie was doing her makeup, and Adair was doing her hair. Everyone was in damage control mode and appeared to be aware of Amber's injuries. Remember Adair telling Amber not to touch her hair because he had styled it to cover up where the clump was missing, and Melanie telling Amber she was going to do a certain kind of lip to cover the swelling. We all went to the studio and were together in the green room before the show. Melanie and Adair did touch-ups to Amber's hair and makeup, while Samantha and I sat on a small sofa. I remember Samantha put her arm around me as if to comfort me, and I leaned in towards her. I thought the story was that Samantha comforted Amber. So now let's get to the testimony that Melanie actually gave. She said that, so on December 2015 is the day before the James Corden show, which was December 16th. I'm having a little trouble exactly remembering the December 15th event. I'm going to tell you what I remember. I was supposed to go bowling with my husband, and I was supposed to go bowling with Amber by my house. I do believe around 8:30 or 9, and she never showed up. So that was that. I went back home, and she did send a text around maybe 10:30, which I'm sure you have in your files somewhere, basically saying, I asked her if she's okay, and she's like, no, not really. Johnny came around to talk. We had a fight. I said to her, do you need me to come over? And she said yes. So I came to the penthouse on December 15th. What did you see when you got to the house? Well, a couple of things I remember is entering penthouse 5, which I do believe was the number of the penthouse that they lived together. You entered, you had a small corridor, and then to the left. When you turn left, the kitchen is there and the kitchen counters. So a couple of things I remember is the writing in the gold paint. And she remembers what was written there. She has a photograph. I understand the pressure of time. I know this is so hard to look at. If it's not an issue of the fire. Okay, well, our cross-reference goes. So, Miss English, you have described the flatulence. You saw it on December 15th. What about the condition of Miss Heard? She was a little erratic, upset, in between sad and upset and furious, and just a lot of emotion, but she definitely looked quite distressed. Did she tell you what had happened? Correct, she did. Can you tell us what happened? Well, she said Johnny and her had a fight, and the main thing that stuck in my head that I remember in the incident was the bed, that he tried to suffocate her. Those are her words. Now, did it come time for you to apply makeup on Amber? Yes, that was on the 16th. So there is no questions about whether Melanie saw any injuries on December 15th, saw any hair pulled out, or the damage to the bed itself. So suddenly now we jump to doing makeup on the 16th. When you apply makeup to someone, is it a special area? It was done upstairs in penthouse 5 in the area that was kind of her closet, but it was obviously a room. This is where we used to do her hair and makeup. What was the light like? Well, the light, I mean, I do not specifically record the light, but the light must have been good because I need good light to do makeup. I have my own light. Did you notice anything about Amber's eyes? Yes, I did. She had minimal discoloration under her eyes on the inner corner of her eyes by her nose. I recall her left eye being a little more bruised than her right. I remember the bridge of her nose being a little red and swollen. I remember, I'm not sure the medical term, like a cut or scab on her lip. I remember correctly the right of the lip. So bottom to the right. I remember correctly. Did Miss Heard say anything about the injuries to her eye? Yes. So that day she recalled the incident to the hairdresser. Obviously I was privy to her telling me the day before. When the hairdresser came, you know, she made the same statement. So Melanie's been waffling back and forth that she was not there the day before. Now she was there before. Rocky never said she was there. Amber said she was there. And then Amber said, I don't know if she was there. So it was about something about Johnny trying to suffocate her. Did you look at her hair, the crown of her hair? I do not recall if I did or did not. Were you present when the hairdresser was given this information? What were you doing during Miss Heard's makeup? You talked about the incident that happened that night. What did Miss Heard say about that? Exactly as I told you, you know, repeating what happened and how you know the injuries. Now you were preparing her for a television appearance. Is that correct? How keen was Miss Heard to appear on the television show? How keen? Not that keen. It was back and forth to see if she was going to attend or not. It was back and forth whether she would attend? Correct. What sort of makeup were you applying? Concealer. I tried to conceal some of the bruises, foundation, you know, full face of makeup. And one thing I do remember very clearly is although Amber's signature lip is red lip, so it's not uncommon for her to have red lip, I remember having a discussion that day that we had no other choice but to do a red lip. Why was that? To cover up the injury on her lip. So she's supposed to have an open injury on her lip. Or maybe it was a scab. Or maybe it was an open cut. You've mentioned concealer. Well, those bruises very effective because to my recollection, they were not that dark or that inflamed yet. Well, she's supposed to have a broken nose. When she put the makeup on, were they still visible? No. Her answer is no. They were not visible. Yet she's already stated when she sees the pictures, she can see the injuries. So this is not making sense, obviously. Re-examined by Miss Waz. Miss Waz, there is just one matter. Miss Inglesis, please. It has been suggested that you are a friend of Miss Heard's. I just want to establish. Did you come to this facility where you are giving evidence voluntarily or not? No. Thank you very much. And what does Judge Nichols says? Miss Inglesis, you have just explained you came here involuntarily. In that case, I would like to again thank you for coming to give your evidence, for doing so under compulsion, and for doing so at what may be an inconvenient time for you there in Los Angeles. Thank you very much. Oh my God. Now we have an important witness statement of Samantha McMillen because she was there, and Amber argued that she came after her makeup was already done and she never saw any injuries, although she did say that she comforted her. On December 16th, I spent much of the afternoon and early evening with Miss Heard, preparing her to appear on the James Corden show. I saw her throughout the day of December 16th in good light and close range, wearing no makeup. So she's confirming I was there before Melanie did her makeup. Throughout the day on December 16th, I could see clearly that Miss Heard did not have any visible marks, bruises, cuts, or injuries to her face or the other part of her body. She appeared as a guest on the James Gordon show that day. After the show, Miss Heard said to me, "Can you believe I just did that show with 2 black guys?" Miss Heard did not have any black eyes and had been visibly uninjured throughout the day and at that moment. I later learned that Miss Heard had accused Mr. Depp in court filings and media of violently abusing her on the previous night, the 15th. As I was leaving Miss Heard's company on December 16th, I overheard Miss Heard say to her friend Raquel Pennington, who came to the show with her, "Make sure to get those pictures on my computer," although I did not know what photo she was referring to. So that's Samantha's statement. She was there, did not see any injuries. And then Mellie got into an argument online with people. There was no effect. The only thing I did from the original is take a couple spots of her cheeks off. She was talking about that she does not touch up photos. And yet, as you'll see here, the photos were very much touched up. These are the originals. And then the prettiest portrait because it's been touched up. Now, we saw so far that Melanie is doing everything she can to avoid giving testimony. She believes her career will be harmed. She believes she's violating confidentiality, that she's shown her other clients that she would throw them under the bus. Melanie had a text exchange with a fan, and it was documented, and you take that for what it is. But I think Melanie gave help to her friend by giving a declaration, thinking this was never going to come to court. And then now remember, Johnny filed against the NGN first before Amber, so she knew that was happening. I just don't think she ever expected any of these to go to court. She didn't expect to have to deal with them. And then when it all became real, suddenly it was scrambling to make sure we get these statements correct. So here's one text exchange with her. The other person to Melanie is saying she wasn't abusive toward him. His finger was lacerated. Okay, babe, I can't tell anymore. Can't tell anymore. That's not a lacerated finger. That's literally the top of a finger gone, which is not his. And they said from Amber throwing the vodka bottle. So she did not believe that the picture she was being shown was even of Johnny. So anyway, this court is being filed. It's in civil court. She's being sued for $50 million, which is itself a joke. She wants it dismissed because he has no ground. Well, he obviously did have ground because he won. For him to sue for $50 million shows right there he just wants press and big numbers. She doesn't have $50 million. It's stupid. Question, why is he suing if he has no ground? I don't get it. So this should be her chance to fight back against him. He wants a trial, though. She says, do you have any idea how much money that is? She doesn't fight back. It was settled. Done. It will be dismissed. Just wait. So I honestly believe at some point, Melanie never thought, even though she'd given a declaration to help her friend, that this whole thing was going to be dismissed. And then she got roped into the NGN trial, not only the Virginia trial, and you saw her back and forth. So anyway, back to what we were talking about now. Thanks. I have a few more things. This is interesting. This came out in Virginia. Dr. Anderson states, which sounds like Amber had a plan. Here we go. Dr. Anderson also testified that the couple did not communicate and had terrible skills. She said Amber Heard reported in a phone session, now she has this recorded in her log, a phone session on December 15th that she did not want to get a divorce, but that she wanted to get a divorce. In the same session, she said Heard talked about a strategy of getting out of the relationship. Her therapy notes state, will she have an advantage if she leaves him but files with police for abuse first? Anderson said that on December 15th, Heard came to her office and showed her bruises. So she contacted Dr. Anderson during the day on December 15th about an incident that apparently hadn't happened yet. Now, Melanie did finally testify in the UK. She gave her recorded deposition. Deposition that was edited and used for her video testimony. And on the very day of her testimony, the very day, May 18th, Melanie posted this on her Instagram. Rosamund Pike, her character of Gone Girl. And it's still there. Here's the pictures. There's no split lip. There's no swelling. Both sides of her face are natural here. There's no swelling anywhere. I know if I zoom in, it distorts it. Here she is here. Her lips look perfect. There's no swelling about the eyes. And this is the clincher.
At James Corden show that night, December 16th.
Yes.
What do you recall?
Samantha was a stylist. Samantha was there the day of the James Corden show, as she was always there to get her ready before an appearance or show.
And did Samantha work on Amber before or after you were applying the makeup?
I don't know if she worked on Amber, but when I entered the Penthouse 5, Samantha was there with Amber. So Samantha was there before I entered the penthouse.
Bingo. Samantha was there before Melanie entered the penthouse. Remember her to give in prior testimony that her makeup was complete done before Samantha had arrived. So there is a big contradiction. So she had no makeup on, and that completely confirms what Samantha claimed. Samantha did not testify in the Virginia case, although I don't know why they didn't call her, but the jury obviously came to the right conclusion. And here again with Depp team.
And when you went to the penthouse on December 15th, I believe you testified before that you didn't see any injuries on Amber Heard that evening, correct?
Sorry, I don't recall seeing any injuries on Amber that night.
Do you recall if Ms. Pennington was at the penthouse that evening?
Yes.
Do you recall if anybody else was at the penthouse that evening?
I don't recall.
But you do remember Ms. Heard being there and Ms. Pennington, correct?
Correct.
We finally have her officially on record. I was there December 15th that night with Raquel Pennington. I saw no injuries. She's not even mentioning the hair that she saw on the floor or the writing on the countertop, which is obviously the next day when she came.
Did you take any photographs of Ms. Heard the evening of December 15, 2016?
No.
Do you recall being present when any photographs of Ms. Heard were taken on December 15, 2015?
I don't recall.
Now, Amber says that she was there with Rocky. Rocky says she took photos of the injuries, the hair, the bed. She took it all on her phone.
Do you remember being present when photographs of Ms. Heard's injuries were taken on December 16th, 2015?
No.
So she has no recollection of photos being taken. I cannot tell you what it was like to sit there in this courtroom and hear this because I was bursting.
Did you take any pictures of Ms. Heard and her injuries on December 16th, 2015?
No.
So there you have it. We got quite a lot of inconsistencies, but in the end, push come to shove, Melanie admitted, I was there the night before with Rocky. She doesn't remember any injuries the night before. She doesn't remember taking photos. It is the next day. Samantha had been there before her, so Samantha saw Amber first. Samantha testified that she saw her injured. Melanie testified that she did the makeup to cover up the lip. We saw those pictures. Luckily, the Virginia jury didn't believe Amber Heard. Remember, Ben Rottenberg said you only have to find one instance, just one instance. And after all this testimony, they apparently believed it was a hoax and believed Johnny and believed Amber was lying with malice, with knowledge. Thanks for watching today. I hope this, I know this was a crazy travel to get Melanie on the stand and how hard she fought to do it, how she claimed she was getting death threats, harassment. It would harm her career. She didn't want to be associated with the Sun. And she also testified that her and Amber were no longer friends, that things got just too tough to be a friend of hers. So they are no longer friends. Well, anyway, thanks for watching. And this is one of those deep dive pre-trial battlefields to get to Virginia. And I appreciate you watching. Please like, share. And I bought all these documents. I have a PayPal link that I'll put in the description. And thank you for everything. Take care.